My name is Thomas Bona, and I'm a partner at Pillinger Miller Tarallo, and I'd like to welcome you to Pillinger Miller Tarallo's podcast, Risk Matters. Risk Matters will examine thought-provoking insurance and risk management topics by interviewing leaders in the insurance industry. Our host today of Risk Matters is Jeffrey D. Schulman. Jeff Schulman is the managing partner of Pillinger Miller Tarallo's Upstate New York offices in Syracuse and Buffalo. He is highly experienced in construction, environmental, risk transfer, and transportation matters, among other areas. Our guest today is Frank McLaughlin. Frank is the Senior Managing Director for Liability Claims and National Property Claims for BITCO Construction Group, with over 20 years in claims leadership positions. Here's Jeff.
Oh, thanks, Tom and Frank. It's great to have you on the show. For those of you who don't know, Frank brings with him a wealth of experience and knowledge, and we greatly appreciate you taking the time to be on the show and share some of your experience and insight in the field of risk management. I'd like to start kind of at the beginning when you were a young, idealistic Frank, and you applied to and got into Providence College. Go Friars, by the way. How'd you pick Providence? Why'd you pick Providence? And tell me a little bit about that.
Well, my parents were college professors, and my father had a pool of colleges from which I could go and get reciprocal tuition, a tuition exchange, essentially. And Providence offered me a full tuition right off the bat. So I applied to only one school, and I liked Providence, and I probably couldn't have gotten in the schools I liked better. So
excellent. What did your parents teach?
My father teaches philosophy, or did, dearly departed, and my mother was an English teacher.
Oh, fantastic. And you were a history major, correct?
Correct.
What'd you like to study in history? What particular discipline?
Well, I did a lot of, just because it's an American institution, we did a lot of revolutionary, sort of up through the Civil War, through the foundings of the country. I also specialized in English medieval history when I was studying abroad at Oxford.
Oh, wow. Wow. Impressive. Do you still read history? I like to read, I don't read a lot of fiction, but I do like to read a lot of nonfiction. How about you?
I don't read as much nonfiction as I should. I read a lot of fiction on my computer screen every day, reading these claims. So,
oh, we'll get to that. We'll get to that with.
But I do enjoy a well-written history.
Absolutely. And were you at Providence during the Rick Pitino era, or?
I was. I was abroad when they went to the Final Four, but I was there for that.
Sorry, you broke up a little bit on there, but you said you were abroad at Oxford when they went to the Final Four?
When they went to the Final Four, correct. And so it was an exciting time to be there.
Fantastic. Fantastic. I'm a Michigan grad, and I was there during the Final Four in the 80s and the Fab Five and all that. That was an exciting time also.
And that was when they called the timeout with no timeouts left?
I graduated the year later. I was there when we won with Ramil Robinson and Terry Mills and that whole crew. But yeah, the next year, unfortunately, Chris Webber's infamous timeout during the North Carolina game. Yeah, that was a shame. We won't go there. So talking college, then you became a Scarlet Knight. Is that right? You went to Rutgers Law?
Correct. Yeah, I went to Rutgers for law school.
And when you decided you wanted to go to law school, what were you thinking about your career at that time?
Well, at that time, I'd been at American Reinsurance, now Munich Re, for about 3 years. And I just saw that in order for me to proceed in the industry, I either had to get a lot of experience at the primary level in order to understand the reinsurance business, or I had to get some professional training. So I became a CPCU right off the bat. And then I felt like I really needed to, if I were going to stay in insurance, I needed to get a law degree, in my estimation, or it would be useful to have. And on the other hand, if I didn't choose to stay in law or in insurance, I would have a wide array of options, or so I thought. So.
And do you feel that your training in law school provides a different approach than, say, some of the colleagues that you've come across throughout your years in claims management?
Yes. I mean, getting a law degree really teaches you how to think, how to articulate your ideas, how to think logically, how to construct arguments, how to build a case one way or the other. And it just gives you a much more of an analytical track than I, had gotten in even as a relatively elite college student. It added layers of knowledge, of questioning, of and basically how to marshal arguments in support of a position. And so it's very useful, I think, for anyone in insurance business.
Yeah, no, I definitely enjoy, a lot of the adjusters that I typically deal with have a law degree, and they approach problems in a very insightful way and tend to peel more layers back, which is, kind of the training that we all get in law school, right? I think, as I recall, you practiced for a couple of years too. Is that correct?
Yeah, I did. I spent 2 years at the firm Kroll and Tract, which was a old school Lloyd's of London defense shop in New York, about 50 attorneys. It's now has a different name, as many law firms do.
Yeah, and did you do like what we call traditional defense work and handling claims?
Yes, I was basically doing defense work. It was a Lloyd's program, predominantly construction. So we were dealing with risk transfer issues and labor law, 200, 240, 240 sub 1, a lot of those issues. And we also served as a national coverage counsel, so that we would look at tenders that were coming in Ohio or California, and we would evaluate that on behalf of the London market. It's a model you don't see as often anymore. It's still prevalent with some European carriers to utilize a law firm rather than a TPA, for example, or what would consider a normal claims operation.
Sure. And was there any overarching reason or motivation for you getting out of the practice, so to speak, and into insurance, for like firsthand?
Well, you have to remember that I was in insurance before I was in law school. So I had 3 years I had a CPCU and ARM. And as I looked at you have to be honest with yourself, right? And tell no lies to yourself, at least. And I just looked and I said, I don't operate as quickly on my feet as these very talented attorneys I see around me as litigators. Maybe I'd be above average, maybe I wouldn't, but I certainly didn't feel that I had great litigator skills. And if I can't be great at it, I don't want to do it. I needed to find a milieu that would work for me. And that has always been, insurance claims. I enjoy the work, and I think I'm pretty good at it.
And you are. I mean, I've seen you speak in various conferences and, really share some of your expertise. Did you have some early mentors that gave you some real good lessons that you can share that, might help someone who's younger listening to this, that just entering the field and could use some of that, take with them?
Yeah, well, one of my early mentors was Jack Muldoon when I was at American Reinsurance, and he had a lot of pithy sayings and everything, and there's plenty of that. The juice isn't worth the squeeze, and those kinds of folksy things. I could go all day on those. One of the things he told me is that has resonated with me is that we're in this business to try and find coverage for the insureds. When we look at every claim, we should be looking to establish coverage, and then when you keep looking for it and it's not there anymore, then you have to say, well, if there's no coverage, how do I position this? To either find the insured a different avenue, a different policy that they might want to pursue, or just to let them down as nicely as possible. This is simply not something they purchase as part of their insuring agreement. So I thought that was a trenchant observation early in my career.
I think that's a great thing to hear. From my perspective, I would ask this question: do you think that there are a lot of people that are trained quite the opposite? And do you see that in your path, that, they're trained to disclaim somehow or find a disclaimer?
Yes, you definitely see it, especially you don't see it with the big carriers as much. The Liberties of the world, the Zurichs, the AIGs, you don't see it quite as often there. Where you see it is these often as smaller, maybe perhaps monoline companies, or surplus lines companies that are not as easily feel themselves more insulated from oversight. They're working off non-traditional forms, manuscript forms usually. Mm-hmm. So I think you do see that, and you see that the reflex reaction is to deny coverage.
Yeah.
And do quite the opposite of what I try to do, which is try to find it.
Sure.
doesn't always make me the most popular employee in the organization when I find coverage for them. But yeah, I think you have to give people the benefit of the bargain, especially on a contract of adhesion as these are.
And do you find that helps you to work better with the underwriting team when you're looking at a claim?
Yes, I mean, we have an excellent underwriting team where I am now, and I've been surrounded by some excellent underwriters over the years. One of the things I do is I get involved in reading the policies before they're issued, making sure that our risk transfer language in the underlying contracts that are being executed by the client insureds will be supported under that state's anti-indemnity statute should they have one. I'm also looking at the insurance requirements to make sure that what our contractors are, which are traditionally general contractors, that to make sure that they're getting as much downstream risk transfer as they can, if not by the terms of the contract, but also by the insurance requirements that are included as an addendum to the contract. So how much insurance they should have, of what variety should they have. If you're a trenching company, do you need to have pollution insurance in the event that you strike a sewage line? So we always kind of, as a claim person, I'm sort of looking ahead to what the line of work and making sure the coverages will marry up effectively.
Yeah, I think if I'm not mistaken, your law training probably helps you there to see that through, see how, and your claims experience to see how something could go awry and then, prevent that by being proactive.
Absolutely. You're always, as an experienced claim professional, or as you would as an attorney, you're always going back to all of the lessons you've learned over time. You're saying, well, I'm pretty sure that Florida has a requirement that ties the value of the contract. You have to tie the insuring agreement to the value of the contract, for example. So I might not know it off by heart because I work in 50 different states, but I know that there's an issue there. I want to make sure that we've addressed it. I seem to recall it. Then I get out my treatises on risk transfer and I look it up and I just sort of put my legal researcher hat on for a bit, and then I look at some of the cases and see what they say. And I try to give underwriting the benefit of my experience so that they can make a rational, educated decision about the risk.
Absolutely. And so you touched on risk transfer. I had just a note written down. There's obviously a lot of trends in construction industry, especially with risk transfer. And I just had, like one note on my pad on this with OSIPs, CSIPs, wrap up policies. And what are your thoughts on those policies as they relate to construction projects?
I have a number of thoughts. And first of all, I probably should have noted that I speak solely on my own behalf. Nothing I say reflects the
company
feelings of Older Public Group, BITCO Construction Group.
Understood.
An OSIP is a marvelous piece of insurance. You can price it. It generally has a large deductible. It's very advantageous for doing any kind of contracting in dangerous venues. New York comes to mind because of the labor law. There are other, Chicago comes to mind because of the risk transfer issues. If you're doing work in Illinois and you're going to end up in Cook County, you're probably going to want to make sure that as much as possible that you're involved in a RAP. Now, the problem is the RAP is you don't have anybody to point at. But there's also a downside to RAP, and that's when you have, when you don't have a mutual intent memorialized within the agreement. So if you have a situation where one of your attorneys, if you have 5 entities that are sued as a result of, say, a bodily injury accident at a work site, and you have 5 different suits go out there with potentially different allegations against the other parties, and then there's the thought that this needs to trigger 5 different defense obligations with 5 different law firms, and then everyone starts pointing the finger. And the idea that you've now lost the whole benefit of the benefit of the RAP is it cuts down the cost. So you are shutting out the internecine battles between various insureds.
Sure.
Now, if you get rid of that, now you're paying 5. Now you've insured 5 parties that are potential tortfeasors, and everybody's trying to point the finger at the other party to open up a professional liability insurance. It just becomes a morass. So I
Sure.
think what you need to have is language within your wraps that make it clear that there's a common purpose, a common goal, and that there's no suits allowed between defendants such that would trigger an obligation under any of these entities' general liability policies. So what you want to do is say you want to carve out, pollution or professional liability so that you can go after members who've taken on a job that's outside the scope of the RAP. Now, the RAP generally is not going to include your actions if you are doing a design build, or if you're doing taking on greater responsibilities in terms of the design. You're drawing up architectural plans, or you're redesigning a French drain or something in a way that hasn't been done before in order to suit the accommodations of the particular project. Once you get in there, you could have an independent obligation that needs to have independent counsel and trigger a different policy to potentially respond.
Sure.
But the best way you're able to do it is when all of the defendants are represented by the same counsel with a unified purpose to defeat the claim or to manage the value of the claims such that you reach an economical resolution.
It's interesting that you put it in terms of defeating the claim or managing the amount of the claim. Jeff Miller always has a phrase that we're in the resolution business, and I think that you would probably agree with that. And it's either can we get this case dismissed, right? You look at early on, or is it a case that, look, we're going to have to resolve one way or the other. We're going to have to either try it, mediate it, or settle it. From your perspective, looking at us as counsel, right? We're lawyers. We're effectively a vendor of yours. How would you say the relationship with counsel is distinguished from other vendors? And I know you have a bunch of them, but our relationship I find is unique, and I'm curious from your perspective how you see it.
Well, most of our vendors, as a rule, are a fee-for-service type of vendor. Either it's an investigation or it's an expert clearinghouse, or there's vendors that are doing particular tasks for you, like salvage and subrogation. So all of those are very necessary, and those are relationships we need to have, and they're largely as a result of outsourcing that's been going on for 30 years in the industry, moving investigative functions out of claim departments and into a private vendor who's going to do your investigations and do your fraud analysis and your fraud checks. And it's just part of the cycle of the business. Sometime that may come back into the companies. But with counsel, it's a little different, right? Because we have a high degree of interaction. We're on the phone with you, a couple times a month to talk about a case. We are intimately involved in devising a strategy for resolution or trial. And we naturally defer to counsel on areas that are particularly their expertise. When I first got into this business, I would rewrite drafts. People remember me. I would stay up until 2 a.m. rewriting a summary judgment brief for a case in Illinois or in Missouri. And that got old really quick. So I have to trust that you guys are going to have people that can competently do the actual work of the files. Now, the advantages to me is that I'm working with people I trust. If I can't trust you, I'm not going to work with you anymore. So that's the difference, because we are going to see each other again and again and again. If not as my representative, you might be representing a co-defendant. I want to build that relationship as closely as possible with you to make it easier the next time we're sitting across from each other at a mediation table. But on the other hand, I need to get the best out of you. So I need to make sure that the reports are timely, that they're substantive, that every time we touch a file, that we're moving it actively towards a better resolution than we had thought. So that could be, did we get the right IMEs? Did we depose a doctor if we're allowed to? Are we building the blocks to make a better resolution on the case? Did we get all the witnesses? I give a tremendous amount of respect and credit to my defense counsel for being incredibly creative as to how they attack these problems. And what I'm there to do is say, there's things I can do and things I can't do. There's things I can agree to. I'm not paying this guy $1 million for this ridiculous injury. He's 300 pounds, and he's been an iron worker for 25 years. I'm not paying for a new knee.
Right, right.
So, I mean, and that's where I have to sometimes draw the line, and I have to say, this is what, and the reality is that I negotiate more cases, or when I was active on the line, my people are negotiating more cases in a month than any of my attorneys. They're settling more cases and they're seeing a wider array of claims, because you might be working 50 claims at a time. This person's working 200 claims.
Sure.
Up, and you're just seeing a lot more of the same injury over, and so you get a handle on what a value of a arm off in Cook County, Illinois is. I mean,
absolutely.
And you'll know whether that's a $15 million case or a $3 million case. And so there's the things we bring to the table that I think are necessary to achieve the best results, but we also couldn't do it without you guys.
Well, we appreciate the partnership, of course. And, what do you see or hear from, the people at the desk that's the most often repeated complaint about defense counsel? Trick question, huh?
Yeah, I think you're always going to get people who don't think you're responsive enough. And I tend to be having been on both sides of the fence, I tend to be a little more accommodating on that issue. A lot of people are very detail oriented in this business, and if they don't get the report on the 15th, they want to know why. If they don't have it on the 17th, they're starting to get mad. I tend to be a little more relaxed on those issues, as long as I get it and I get your best work. And I realize things come up and you have a more important motion to brief that has to be dealt with, and maybe something gets backburnered for a couple of days or weeks. Usually these things aren't fires that are complete emergencies. So,
and on the flip side of that, on a more positive front, what do you hear some of the best things, patterns of behaviors for defense counsel that you see, and that if you could have, a moment to take a young attorney aside and say, hey, you're going to succeed if you follow kind of some of these best practices.
Yeah, I think that everybody has to realize that this isn't going to be your last case, and you don't have to build into oblivion. The firms that get the work that I want to give are the firms that do reasonable work, do good, solid work for reasonable cost. And that's my, this is, I hate to say it, Jeff, but this is the ham and egger stuff. I mean, we're doing defense claims with, $1, $5, $10 million in value or less or more, but we're not dealing with, $500 million real estate transactions. And there's a whole category of different types of attorneys that can cost me $1,000 an hour. And so what I'm constantly doing is saying, what's the right tool for the job? I need, a person with it, and a great construction defect attorney may not be the right guy for a slip and fall, in a parking lot.
Sure.
So we're constantly balancing getting work to the right level. We're doing that in our organizations, and we're doing it with regard to our vendors. So we're trying to make sure that we get work to people who are appropriate to for the tasks to be completed. I also want to see that there's good oversight by managing partners, or whether it's a senior, somebody that I can call when I'm not happy with the work I'm getting. And I just don't want to have the back and forth with the associate or the junior partner. I want to have a name I can call and say, I'm mad as hell and I'm not going to take it anymore.
Right.
And Jeff's that guy. Jeff's that guy at your firm. So
yeah, of course. And he's definitely good at fielding those. Yeah.
But that's important. I think that's to have the responsiveness is something that is not easily duplicated. Some firms get it, some firms don't. And some firms just over litigate the cases without really doing the cost benefit evaluation. So that's why budgeting is so important to us. We need accurate budgets, and so we can project, up until mediation, what is this going to cost me on defense? And if it's $125,000, that's fine. But is there any way I can use that $125,000 towards a settlement now that's going to be within the range of what I would ultimately expect to pay at the end of the day. So if there's an opportunity, and it's a big if, but if there's an opportunity to avoid incurring something I know I'm going to get, I'm going to pay those defense costs. I might win or lose a trial, but the one certainty is defense costs. And can I use that to leverage a better early result with just having the knowledge of what I'm going to be spending going forward? So I don't know if that's a clear enough answer, but.
No, it's a great answer. And, I'll tell you in terms of legal budgeting, because I do a lot of the budgets at the firm, and I always tell my associates that $1 in defense equals $1 in indemnity. And so if you feel that you have an opportunity for early resolution for a value that we've roundtabled the case for, and you could do it before depositions, that's a great result. And that's something that you should look for, because, again, $1 is $1. And if we can save it and move on to the next case, again, being in the claims resolution business, that's what we want to do. So, we're both kind of old school, right? And we touch on a lot of things, in a qualitative way. And what I'm seeing more and more of, a lot of carriers are using metrics, and they're analyzing metrics in terms of how they evaluate counsel and how they evaluate results. I was curious what you thought of the current metrics-based merit system, for lack of a better phrase. If you had thoughts on it, or you just don't use them, and what your thoughts were.
Well, I look at metrics through two different prisms, right? So I look at it as the performance metrics for my staff. And so I have, if a team of individuals is managing X number of files, who's managing for example, the expense profile. So if I have 5 people on my team and one person is paying 20%, 20% in defense costs, why is someone else paying, 1-to-1, 100% defense costs?
Sure.
Now, are they handling a very different book of business? Is one person more proactive? Is one person, paying too much money at the beginning to just simply settle the cases? So you have to look behind the numbers. And that's why I'm not a huge metrics fan. I mean, you need it in a larger organization. I've always been able to use them. How often are people putting notes in their files? The usual quality control issues that you face as an organization.
Mhm.
Now, as far as what metrics do I apply to my defense counsel, it's much simpler than that for me. And you either get the results I want for the price I want, or we simply don't use you again. It's that simple. If I see a pattern of where I'm not getting the results I want, it's time for me to move on. And I would hope that my litigation manager would be, singularly focused on that. And we're going to continue to get claims. Let's get those people, those individual attorneys who are working the hardest for us, getting the best results. They're the ones who are getting at my work, because at the end of the day, the buck stops with me. It doesn't go any further.
Mhm.
And I'm responsible for your results. So it is not as easy as a simple metrics in my mind, but you can look and look at a body of claims and have a couple of check marks. So is this a New York labor law case? And at the end of the day, what is the ratio between expense to dollars paid? And then you can look at that, and you're going to see some firms that have a much higher ratio, and firms that have a low ratio. And then you have to look behind the numbers to see if they're much less complicated claims, which it could be. You might be sending some claims to a firm that you consider a heavy hitter. But once you have a chance to look behind the numbers, you're going to have an opportunity to see how you can improve your own culture and organization and panel.
No, I love that. Behind the numbers is really important. The numbers are important. I agree with you. The metrics are important, but looking behind them is probably equally as important. I always get this question when people find out what I do. When they find out I'm an attorney, they don't want to talk to me. But once I get past that, and they understand the kind of cases that we handle. They kind of peak up, they're interested because all of a sudden it's real world. They can understand an accident. To your example earlier, they're not necessarily interested in a $500 million real estate transaction, but they can understand a horrific trucking accident, for example. So I always get this question, what's the most challenging case or the worst case you've ever worked? So I was wondering if you had one, or it doesn't have to be one, could be a couple, but have you had one case that stands out in your mind as just the worst one, or just the most challenging one you've ever had, and something you could share with us?
Sure. Well, the one thing you have to remember on these questions is that you're still an active attorney. You're an active attorney, so you're continuing to see and try cases as you go through your career. On the claim handler side, all of your good stories come in the first few years of your career, because if you're any good, you're moving on to higher levels of authority and positions, and you may not see as many, be on the front lines on as many claims. You may see them, but you're in a large claim committee, or you're just supervising somebody else who's having all the fun.
Yeah.
But early in my career, right after I joined Risk Enterprise Management, I was in charge of managing all of the home's TPA administered business. A fascinating job. I was thrown out in the deep end, and I got to do a lot of great cases there, and too many to mention. But one that stands out is the Cat Dancers Ranch case. This was later turned into an HBO movie or documentary. So an older couple, maybe in their 50s, had a career in Agagio dancing in New York, professional dancers. They migrated, so many people do, to Florida in the middle, to take up the next phase of their life. And so they said, we want to continue dancing and go to senior citizen homes and that kind of thing, schools. And what we think would really make us an attraction is if we had a large cat. So they went out and purchased a baby cub of a Bengal tiger. And so they purchased this tiger, and then they decided, well, that we have to have somebody to train this tiger. So they found a young man to train the tiger. Ultimately, this became a very polyamorous relationship among the husband, the wife, and the gentleman trainer.
Mm-hmm.
And so they were all deeply interconnected. They were living together, sharing a room, the whole 9 yards, and they're going out and doing the dancing, and he's doing the tiger training.
Mm-hmm.
But one day he's in the enclosure with the tiger. Some contractors are outside. They drop a load of steel on the ground. It clatters. The tiger takes a single swipe and swipes out Carl Izzy's head. But the tiger was not executed on the spot or put down, because he was very remorseful. He went and buried his paws in his face, his face in his paws.
Yeah.
And it's the case of the remorseful tiger.
Mm-hmm.
So the one guy's dead, and then the wife retreats to her bedroom, doesn't come out for 20 days, after which time she took no food, no nourishment, didn't wash, and she entered the tiger's enclosure to, finally just to reconcile with the tiger after he killed her lover.
Mm-hmm.
And tiger didn't recognize her. And tiger went tiger.
Oh, boy.
And so it kills her. The tiger escapes the cage. They have a big roundup. They shoot the tiger.
Mm-hmm.
So my client at this time is the husband, Ron. And so Ron is lost his gay lover. He's lost his wife. He's lost the animal that provides his means of support. It was a very sad case. And he was getting sued by the mother of the young man. And I had a young attorney on the case in Florida, and I wish I could remember his name. And he kept sending me reports telling me how close we were getting to settling it. I said, I'm never paying a dime, not a dime to a tiger trainer who gets killed by his tiger. And there's a very famous case, I guess, in New York, Ron Turcotte, who was paralyzed at either Saratoga or went out in Long Island, Belmont, when he got trapped between the rails.
Mm-hmm.
And the Court of Appeals in 1986 came down with a decision that said there was no responsibility for that.
Mm-hmm.
And Florida does often sort of follow where there's a gap in law, often follows New York precedent, or looks to New York precedent.
Yep.
But in this case, I simply said, we're never paying this a single penny. And I kept getting the calls every day as the trial, went on. I'm like, we can get it for $100,000, or down from $2 million or whatever they wanted originally.
Sure.
I'm not paying a dime.
Yeah.
And we got a directed verdict because I thought it was the
Fantastic.
case that I would always, if I'd been a trial lawyer, this is the case I want to have. And this is,
Right.
you know, you just go out there and argue, make it an argument. It's like a mock
Yep.
trial because it's so sympathetic, but it's so ridiculous. So I very much enjoyed that. I stuck to my guns. I never even alerted management there was a trial going on because I thought they would try to make me settle it for a very nominal sum.
Oh, is that
So,
right? Oh, that's
yeah, I
fantastic.
decided to die on that mountain. If it didn't work out, I might have been looking for a new career.
Yeah, I'd say, I guess it worked out well because look where you are now. So it was a good call. It's true that you were a competitive boxer. Am I right?
I did it for a number of years. I started my boxing career at Oxford University back in 1986 and 1987. I boxed on the Oxford, what they call the Blues team, and earned my blue against Cambridge, and actually won the national collegiate title while I was there as a
That's
lightweight,
awesome.
9'7", 132 pounds. And it's, you know, that was a great experience. And I came back and did Golden Gloves and Diamond Belt and all that stuff here in the city. And in back in urban America, my losses started to mount up. I was perhaps not as good as I believed I had been against college kids.
Well, I've seen you recently and you look great. And so I think you could probably box in that class right now. What did boxing competitively, what kind of lessons did that teach you for handling this topsy-turvy world that we're in?
Yeah, I think I want to be careful answering that question because I think we have a tendency as older claim professionals to sort of put a sports theme on it. And I think that can be a little marginalizing to people who aren't, you know, perhaps into sports, but could be really good claim people.
Sure.
Who don't, and there's a lot of people who don't, you know, play sports competitively, but have all the competitive instincts they need to be a claim person. So I want to make that caveat.
No,
On the other hand, I did learn a lot about myself through boxing, and I learned a lot about how to deal with adversity in the moment. So when you're knocked down your keister, you have to get up and you have to soldier on. You have to figure out. You have to come up with a new plan. Try to come up with a winning plan. And if you can't win, you know, lose gracefully.
Yeah.
But also, it made me a fairly aggressive person. So I tend to do best when I'm going forward. I don't like to fight in retreat.
Mhm.
I just kind of want to always be moving forward, trying to push, whether it's a claim file or a litigated matter. I want to try to push that at all times and take risks where appropriate and balanced. But for me, I harness the aggression. I like to be the one who you know, strikes first, keep up the pressure and make it not fun for the other side. And hopefully you can leverage that into a better litigation result, a better claim result.
Yeah, I think that's a great answer. And, you know, I will say that if you had painted, you know, and had, you know, gallery, you know, paintings hanging in galleries, I probably would ask you how that affected how you approach claims and claims handling. But you do bring a unique experience from boxing competitively. I mean, very few people have done that in their lives. And I think that really has translated into how you handle yourself in a very positive way. So no interview in 2021 would be complete without at least touching on the pandemic. You know, we all love to talk about it. But I think, you know, obviously it's affected every business. And I think you can bring a unique perspective in two ways. You can kind of share with us how it may have affected your business directly, the insurance business, but also how it might have, and it continues to affect the construction business. And I'm curious about both.
Okay, well, I think that as you well know, insurance is a relatively staid, old-fashioned business compared to many of the other jobs that are available to kids coming out of college right now. But what we've found, and I think most firms found, we were able to transition seamlessly to a work-from-home environment. Everybody had laptops. Everyone had. I had it when our team was putting together, you know, a 1 day a week work from home previously, I just made my people all get monitors, get an extra monitor so you can actually work effectively when you're home. And once people had that, their productivity is better than it was, arguably.
Mm-hmm.
What we lose a little bit of the face-to-face communication. There is some dissonance on, people tend to, I think, operate more independently than they might if my office was right around the corner and the door was open and they knew they could come in and bounce ideas off me. You might as well have somebody, buy into your approach. So I miss that. But I think that when you're paying, $45,000 a month for 10 offices in Midtown, and you're working effectively without it, I think a lot of companies are saying we don't necessarily need to have brick and mortar space, or we don't need to have the same amount of brick and mortar space as we did 2 years ago.
Sure. Sure.
So as far as the construction business, what we saw early in the pandemic was a complete drop off in projects, in much new construction. And I think that's across the board. There were supply chain interruptions that caused, rising lumber prices, and the profit margins weren't there.
Mhm.
So I'm not by any means an expert in the construction industry, but it definitely slowed down. When it slows down, you have fewer accidents, you have, fewer cars on the road. Construction trucks are notoriously bad actors, running into the back. It's just, they're big, heavy trucks, operated by people who are in a bit of a hurry.
Yeah.
And you're going to have a lot of accidents.
Mhm.
So that we had a big drop off in accidents. We had a big drop off in, what we were seeing coming in the door. Now that's starting to change a little bit. I don't think that's a permanent. I think, whatever you think of the, trillion or $3 trillion budget increase to cover construction and infrastructure changes in America, whatever you think about that from a political, whether we should spend it, whether we shouldn't,
Mhm.
it is going to be good for the industry.
Sure.
When you plug $1 trillion into projects, that's going to create more opportunities. You're going to have more people entering the market to compete for these resources, and that's going to create more clients and for people who are properly positioned to underwrite.
Absolutely.
So I think that's what we're going to see. I think we're going to, and then I think as the supply chain gets fixed, as people feel that they can, get back into the factories, the warehouses, the lumber yards, once that all picks up again, I think some of the costs will go down, and we'll be able to build a little more. So that element of the building slowdown will be dissipated, I think.
Well, that's a positive note on which to almost end the interview. I want to thank you so much. We're going to do what I call the lightning round right now. I'm going to ask you some questions, and I'm going to ask you to pick one or the other. First thing that pops in your head. Are you ready?
Sure.
All right. Telephone or email?
Email.
In person or Zoom?
In person.
TPA or broker?
TPA.
Mediation or trial?
Mediation. I get to run the mediations.
Beach or mountains?
Beach.
The book or the movie?
The book.
Pizza or pasta?
Pasta.
Washington or Lincoln?
Washington.
All right. I know the answer to this one, but I have to ask, pro football or college football?
Pro football for me. I went to Providence. We didn't have anything above club there.
There you go. Okay. And last one, Raging Bull or Rocky?
I got to go Rocky there.
All right. I agree with you. Frank, it has been an absolute pleasure to have you on the show. You've been a terrific guest, and I learned so much talking to you, as I always do. I hope to see you in person very soon. And also all of the folks at BITCO Construction Group for allowing Frank to spend some of his valuable time with us and share his experience. It was a great interview. And Frank, I hope to have you back on the show soon.
Jeffrey, thank you very much. I really appreciate you guys including me on this. And I hope this turns out to be a popular podcast for you going forward. So
thank you, Frank.
Thank you very much for your trenchant questions.
Absolutely.